Good afternoon. Hello and welcome. It is time for us to talk about discovery, hearings, trials, and appeals in a New York workers' compensation case. Hello, this is Greg Lois. Thanks for joining me today. We are going to be talking about New York workers' compensation, the trial and litigation process, and we're going to talk a little bit about how we prepare for trials, what kind of discovery we're allowed to do, and then we're going to talk about what happens during the trial, how we present and cross-examine witnesses, and then we're going to end up with a little post-trial discussion about appeals. So thanks for joining us today. Let's dive into the presentation. I'm just going to start off by saying this is not advice to any particular matter. While I will ask people to ask me questions, please, it makes it so much more fun when you ask questions. Please type them into the box that you have on your screen. If you're joining us live, one of the benefits is you can ask a question. Please try to keep it general. In other words, don't give me the case names in your particular matter, and I'll give you my best advice that I can give you. I will read the entire question out loud so that everyone who's joining along with us can hear your question. I will never say your full name. I will say your first name so you know I'm answering your question. And then I'll do my best to answer your questions. But again, please take advantage of the fact that this is a live webinar and ask those questions. I've also added some handouts to today's webinar that are going to be useful to you. So there is a lesson book which covers the materials in today's webinar, as well as I included a copy of the tradesman's complaint, which I'm going to try to work into this discussion. So let's talk about what this presentation is about. Today I'm going to talk about discovery devices or disclosure devices. I'm going to talk about things that we can get without a court order or that we can obtain on our own. And I'm also going to talk about how we use court process in order to investigate our claims. I'm then going to talk about the various hearing types and, of course, discuss a little bit about appeals. And the point of this conversation is this is the exact same training that we give our attorneys here at LOIS Law Firm during their onboarding and training programs. These are the standards that we apply in our cases. And so my goal here is to explain this to you so that you know how to gauge whether your defense attorney is providing you value in your cases. So let's dive in with the first part I want to talk about, which is just a little bit about discovery or disclosure in our workers' compensation cases. One of the most important and most key pieces of disclosure is really something that we don't need anybody's permission to obtain. We can go and get this on our own, and it is a prior claims report. These are often called a CIB or an ISO report because the body that issues these is called the Insurance Services Organization. And this is key. I think every case that gets referred to defense, there should be a Claims Index Bureau report available. Why? It helps us determine if this claimant is a frequent flyer, if they've already injured this body part in another claim, if they've already recovered for injuries to this body part or condition. Totally useful for us when we are going to be investigating a case, when we're going to be retaining experts, and of course, when we are making that argument for apportionment. And really, apportionment's a great way for us to reduce our overall exposure in a New York workers' compensation case. I do want to just remark that we can get apportionment for permanent residual disability. But when we cannot get apportionment for medical treatment or lost wage compensation. So what do I mean by that? What I mean is, let's say you have a worker who has a bad back. They've had 5 prior workers' compensation back claims. They have a bad back. They come to work. They do something that aggravates or worsens their back condition. We are always 100% responsible for restoring them to their pre-injury state. The fact that they had a pre-existing condition means we're trying to restore them back to their pre-morbid condition, which is, yeah, they already had a back condition. But we are responsible for the medical treatment and the lost wage replacement associated with getting them back to their prior condition or their prior state. And we understand it wasn't perfect. So we don't get apportionment on that. We can't say, oh, we're only going to pay half the medical bills because we think half of this condition is pre-existing or unrelated. We do get apportionment on permanent residual disability, which is a dollar for dollar apportionment If we can show that the person had a 50% pre-existing disability and it's not related to our workers' compensation case, we get that apportionment in today's dollars. So the fact that they got a workers' comp recovery 10 years ago for that same condition, we get the apportionment in today's dollars, and that's why it's so important and so useful. So really, one of the first things that we should be obtaining in part of our investigatory process is this Claims Index Bureau report to help us identify cases where we should be raising apportionment or determining that, hey, this might not even be work-related at all. They have had prior 10 claims related to the same shoulder or knee or back. Very useful. Now, when we identify information from this Claims Index Bureau report showing us, hey, this person has had brought prior claims for the same condition, that's where we get into our next step. We can go and subpoena all that information. And we have a very mature and robust process here for doing that. I do think it's important to issue subpoenas to obtain that information, and that's because it then becomes part of the court record. It's useful for us because we can then present it to our experts, and we can, of course, confront the claimant with this prior treatment or condition or recovery in order to obtain that apportionment benefit. So that's an important thing for us to do. Sorry, I'm still on subpoenas here. What else can we do during the investigation or discovery period? Well, covert surveillance. I kind of jumped the gun there and hit the forward button here by accident, but covert surveillance. What is covert surveillance? It essentially means we're going to use a private investigatory firm. We're going to retain some agents to essentially find the claimant, identify them, and then document what it is that they're doing in their activities of daily living. And what we're doing here primarily is looking for contradictory activities that we can then utilize in the workers' compensation case to demonstrate to both the court and maybe to the medical expert that the claimant's condition is not as they are portraying it. And we all know there are money involved in these cases, right? The longer you stay out of work, the bigger your reward. The longer you stay out of work, the more likely you are to get a protracted healing period award. And so we know that there is a secondary gain motivation going on in a lot of our workers' comp cases. And using covert surveillance is one of the keys to us demonstrating this. We always want to link the surveillance to medical records. So I love it when we have medical surveillance on dates. Surveillance on dates they're going to medical appointments. And the reason we want to do that is because we need those contradictory statements. They're going to their doctor and they're saying, doctor, I can't do anything. I just lay in bed, writhing in agony all day because of my terrible workers' comp case. Meanwhile, we have video that demonstrates them going to parties, dancing, going on vacation, doing whatever it is that they're doing. We always want to be mindful about how we're going to actually use this in court. Please note that in this jurisdiction, when you obtain covert surveillance of a claimant, you do not have to demonstrate that to your adversary unless the claimant has already testified. That's really important. That means that the claimant testifies before they get to see what you've obtained in your covert surveillance. And last month in our webinar, we talked at length about the use of surveillance and how we utilize it to demonstrate contradictory statements made by the claimant to their physician, which are clearly contradicted by the evidence that we obtain in our private surveillance. Again, one of the most important things we can do, and I put this under the discovery or disclosure phase because, yes, it is an investigation that we're going to conduct. If we intend on using it in court, we are going to have to reveal the presence of the video. But again, we never provide it to the other side until after the claimant's already testified. So covert surveillance is a really powerful tool to make sure everyone's telling the truth. And let's not skip our non-covert investigation. There are a lot of non-covert investigation techniques that we can utilize to demonstrate that the claimant, again, is not being truthful or not being forthcoming with their treating physician. Lots of opportunities for us to look into their private activities, their gym memberships, their recreational activities, the things that they're posting to their own social media. Great opportunities for us to find and identify these moments where their behavior is not matching their words. I prefer non-covert investigation because in general, It's typically social media investigation, and it's stuff that the claimant has said or posted about themselves. Totally useful for that. How do we find avenues for this investigation? Well, we're pouring through the medical records. We're going to look in there for any statements that they're going to make about their activities outside of medical care. But we're also going to communicate with the employer and say, hey, what do we know about this person? What kind of activity? And are they a weightlifter? Do they go to the gym? Are they in a softball league? Are they a volunteer at their church or for a youth function? Maybe they're their kid's soccer coach. Like, what do we know about this person that we can utilize to help us demonstrate that they have a greater work capacity than what they are claiming to have? The next discovery tool that we typically deploy is depositions. And remember, depositions can be utilized to get to the fact of the matter. The point of depositions is to use it to our advantage, to bring out something that we can utilize to create leverage in our case. When do we request depositions? Generally when there's contradictory medical opinions, where the treating physician is finding 5 years after loss that the claimant still is completely and totally disabled, and our IME doctor says that they're able to work and they are portraying themselves or malingering in a way that is misleading the treating physician. I think that when the claimant tries to bring in new body parts or tries to expand their claim to include consequential injuries, that's another opportunity for us to demand depositions. And certainly, if we think that they are requesting treatment that's not going to be beneficial, like an unnecessary surgery, that's another opportunity to challenge the necessity of that care. Now, we have a very robust deposition process here at LOIS Law Firm, and we've developed this process over a number of years, and because we know what works and what doesn't work. So on the screen here are what I think are the best practices for scheduling depositions. First, we are going to try to cooperate with the other side. We are going to try to work with them to secure deposition dates, usually from the treating physicians, that all sides can agree to and appear at. Unfortunately, treating doctors sometimes skip our depositions, and they claim that they've had a medical emergency and they had to treat a patient, so they didn't appear for the deposition. That's why we always serve 2 subpoenas on the treating doctor. We do that so that we have a backup date in case the first date is not kept by the treating physician. I have a backup date that I've already taken care of. Now, the reason I do that is because I've discovered over the years that the judges will typically excuse or accept the fact that the treating physician has missed a deposition. And usually the treating physician will say something like, oh, well, I didn't come to the deposition. I had a medical emergency. Someone showed up and I had to take care of them. Great. I don't want us to be foreclosed from presenting our proofs and getting an opportunity to cross-examine that doctor. And so what I'll do is I'll always subpoena them for 2 dates. If they miss the second date too, then I can go before the judge and say, Judge, you should throw out all of their testimony and all of their medical records because they're not being cooperative with this process. We have a very robust method for cross-examining the treating physicians. We go through a very specific setting a foundation for that cross-examination, and we always ask them about disciplinary proceedings and license issues. We will always get into that, and what we've discovered is a lot of these physicians who regularly treat workers' compensation patients have a spotty past. I can think of one doctor who was treating physicians and patients for pain management who had had their license suspended for abusing painkillers themselves, and we would certainly utilize that type of information to attack their credibility. Currently, and there's a reason I included the tradesman complaint in case you're unaware of that, there is a federal lawsuit pending against over 40 defendants, including a lot of medical providers. And these are medical providers, if you look at that complaint, that you've seen before in a lot of your workers' compensation cases. The allegations in that federal suit are that they were acting in concert with claimants' attorneys to generate fake claims. In fact, the lawsuit says that some of the doctors were billing insurance companies for medical procedures and appointments that never occurred. So this is really getting to the heart of what we think is some widespread fraud in the workers' compensation system. Our process here has been to ask those doctors when we are cross-examining them, when we're laying actually the foundation for their testimony, isn't it true that you've been identified in a federal lawsuit alleging that you colluded and acted in concert with attorneys to generate fake cases? We've been asking them that in the cross-examinations. Opposing counsel has gone crazy. They really hate us asking these questions, but we think it's germane to the case. And certainly, if our IME doctor had been named in a federal lawsuit for creating fake records, fake reports, and fake testimony, I know our adversaries would be asking those questions, so I don't feel any problems at all about asking them. It's really led to some interesting disruption in depositions over the last month. That federal tradesman complaint was filed on March 6th or March 7th of 2024. So we're watching this, the ripple effects of that play out in our workers' compensation cases on a daily basis. If you have any questions about the tradesman's complaint or how this is going to impact your cases, please type them into me because I'd love to answer those. So cross-examining the treating physician always begins with this foundation of asking them about their history, asking about their qualifications. We have very clear strategies for how we cross-examine these doctors. We try to get the doctors to change or speculate about the claimant's condition. We're doing things to try to undermine their testimony, and we have a very clear technique for doing that. Our process here at LOIS Law Firm is always to write out our cross-examinations in advance of trial. Now, I've been at this for decades, right? And you see the white hair, and you know I've been doing this for a long time. Even when I cross-examine a physician, I write out my cross-examination. There are specific things I'm going after in that cross-examination. There's a specific goal I have for my cross-examination. I believe it should be well planned out in advance. Now, the truth is, during a cross-examination, things emerge, right? It takes a right-hand turn, it takes a left-hand turn, and you got to be ready to pivot. You have to be ready to react to that. And if the doctor starts to make concessions that are valuable and useful to us in defending the case, certainly I want to capitalize on that. So I will then depart from my pre-planned cross-examination, and I will hone in like a laser beam and start exploring those concessions and trying to get them to be amplified, because I know that will help my client. But I do believe that having a ready, spending the time to write out that cross-examination, spending the time to focus on that, leads to a better cross-examination. So we always attack the doctor's credibility where that credibility is at issue, particularly where the doctor is choosing to review or not review certain medical records. Oftentimes, the physician will say, I looked at my own notes. I didn't look at everything that was provided to me, or I didn't look at everything that was in the patient's medical history. Well, that's grounds for us to attack. We're also going to confront the physician with things that we've identified that might not be related to our case. And again, that's where that ISO or CIB prior claims index report becomes so useful. We also utilize objections to try to disrupt the pattern of direct examination and make sure that the treating physician is not speculating or coming up with new opinions on the stand. We want to confine them to their written opinions that they've already reached. So when we think about this stuff and we think about discovery, we think about it has to have a point, okay? Our internal rules here are that the handling attorney or paralegal should be able to explain to the client what they're doing, and it should be simple. It should be quite straightforward, right? So when you ask the attorney who's representing you and you say, hey, why did you do that deposition? They should be able to tell you, here's the goal of that deposition. Oftentimes the goal is to challenge the credibility of the physician. That's it. Sometimes the goal is I wanted to confront the physician with information that we obtained about pre-existing conditions. And I wanted to confront them with that and determine if they would change their opinion in regards to causation, right? That's a great answer, right? It's explanatory. My belief is that if the handling attorney cannot explain to you how this deposition helps your case, and they can't explain to you in one sentence, it's probably an adventure and should not be undertaken, okay? And that's the point of this discovery. I always think that you're doing it right if when you're thinking about your trial or discovery or deposition or appeal, you could fit your whole strategy on a matchbook, right? Simple and straightforward. In my opinion, when I go and talk to an attorney, I say, well, why did you do this deposition? Or why did you think it was important to bring in that piece of evidence? And they start with a story. Well, Greg, in 2019, this happened, and then that happened, and then the judge said this, and then they said that. I'm like, all right, you're lost. You're off in the woods. Give it to me straight. Give it to me simple, okay? Trial strategy should generally be simple. There should be a simple, understood, well understood, and shared goal The client should not be in the dark about why we're litigating a particular issue and what the goal of the litigation of that issue is. That's something that we all live with here, and I think it's a best practice. We deploy it in all of our practice patterns and all of our practice groups. And I think as a client, that's something you should expect. Simplicity, simplicity. As attorneys, our job here is to bring clarity and simplicity to these cases, not to make them more complicated. All right, let's move on from disclosure into hearings and trials. This is where a lot of the work is done. Again, when we walk into a hearing or a trial, we should have a very specific plan. And I believe that the preparation for that stuff begins long before, right? Again, I've been at this for 23 years. I do not litigate by the seat of my pants. I don't walk into these hearings and say, we'll see what happens, okay? That's too risky. That's not what we're here to do. What we're here to do is create specific leverage in these cases. What we're here to do is create an opportunity for our clients. And the only way to do that is to have a very clear action plan walking into any deposition or hearing or trial proceeding. You should know, here's the goal I'm trying to get. Here's what I want the judge to say. Here's what I need on that piece of paper when I walk out of here. Here's what the order has to read, right? That should be very simple and straightforward. We should be sharing that with our risk professional or client and explaining that to them. There should be agreement. Hey, yeah, you're going to go into that hearing. That's the outcome that you're going for. Great, we agree. Let's do that, right? That's being clear. Now, there are some issues that are going to come up in all these cases, and we should be planning or strategizing for them. So, for example, sites of injury. A typical dispute in a workers' compensation case starts off as a right foot injury. 5 years later, it's the right foot, it's the left foot, it's the low back, it's the left hand, it's psychiatric, it's everything. They bring all this stuff in. As the claimant tries to bring in new sites of injury, we should be prepared to refute that and contradict it. And how are we going to do it? Same thing with indemnity or medical issues, treatment requests, wage replacement requests. That should be thought through. What do we want the outcome of this trial to be? Same thing with judicial direction. Sometimes I'm going into a hearing and I just want the judge to order them to do something. How many times does the claimant not execute HIPAA releases? And that hinders my ability to investigate the case. It hinders my ability to get a meaningful independent medical examination. So I go to the hearing and I say, Judge, I want you to direct them to execute HIPAA releases and send them to me. The judge will say, okay, that's interesting, I'll do it. I'll say, okay, Judge, give them 30 days, not forever, not until the next time we come back here. Give them a very specific deadline, Judge. That's what I'm looking for, clear and concrete. Now, we walk into a hearing. I think we should expect that your attorneys know the case. They should know it back and forth, cold, right, straight. When we walk into a hearing, oftentimes, and by the way, all hearings are mandatorily virtual in this context or in this jurisdiction. The New York Workers' Compensation Board went mandatory virtual in March of 2018. So this is long before COVID kept us out of the courtrooms. The court already said, we're going to go virtual beforehand. Okay, I love that. I think it's made us more efficient, made us more useful. My clients are not paying me to drive from hearing point to hearing point or be on the subway going from court to court. Way more efficient. Excellent. This is great for us. Okay, now you walk into that hearing. It's going to be held over WebEx. I believe that our attorney should speak up and speak first. Tell the judge why you're here. Oftentimes you walk into a hearing and the judge says, okay, I got all the parties. Why are we here today? You should be ready to explain exactly why we're here, what we're looking for. 2, 3, 4, 5 sentences. This should be short. This should be an elevator pitch. Your Honor, we're here because we have contradictory medical evidence. We sent the claimant to an IME. The IME says he's right as rain, ready for the Olympics, in great shape, and we want Your Honor to terminate benefits. Really short, to the point. Tell the judge why we're here, what we're asking for, and why we should get it. What are our proofs? These are the things that your attorney should say quickly and get that out on the record. You want to take control of these proceedings, and you want to try to direct and push the court. Remember, our cases, our attorneys, I should say, have a really low case count. We know our cases really well. Opposing counsel doesn't have that luxury. They might have hundreds, maybe 1,000 claimants that they're representing. We should walk in there fully prepared to set forth our position and argue for it. Now, we can be perfectly prepared, but everybody knows, and we talked about this a few months ago in our presentation, that the Workers' Compensation Board affords 5 presumptions to the claimant under Section 21 of the Workers' Compensation Law. In other words, tie goes to the runner. The claimant comes into court and they say, I want something. The judge is more likely than not going to try to grant it. So we've always got to come up with the reasons why the judge should not grant it. And we're not always as successful as we want to be. Okay, if our arguments failed, that's okay. You just have to note your exception. And the rules have been modified over the years. And now, if you do not make an objection on the record, specifically objecting to a portion of the judge's ruling or the preclusion of evidence or the judge not allowing us to present a witness or whatever the judge determines, you've now waived the ability to appeal that. So raising objections with specificity, and sometimes people use the word exception or the words objection. It means the same thing in this context, right? It just means you're raising your argument. If you don't do it, you've waived it. Post-hearing, the hearing's not over when the judge makes their ruling. To us, the transmittal of what did the judge said and what is the outcome of this needs to be presented to our client in plain English within 24 hours. And with really clear directions. Here's what the judge said. Here's what we're going to do. Here's what you're going to do, client. Oftentimes, we're advising the client about how to issue payments consistent with the judge's order. And again, my job is to make that as clear and concise as I possibly can in plain English. I do not want my risk professional to have to go and either A, wait for the judge's order to come out, because it won't be published for a couple of days, or B, have to figure it out themselves. I want to tell them clearly so that we can get a jump on it. We can get moving. Most of our work, 99% of it should be done outside of a courtroom. We should be prepping and preparing and being ready to go. All right, so that's our post-hearing report. Now, sometimes you don't win, right? You've raised your objection and you've got to appeal, okay? Got to appeal. Again, every post-hearing report that I'm going to send you is going to tell you whether or not we should appeal, as well as the probability of succeeding on that appeal. I'm also going to explain to you what we are going to do if we don't get a response to you about that appeal. And I'm going to tell you what you should do in terms of issuing benefits pending the appeal. I want this to be really clear. I don't want anybody confused. I'm also going to explain the appeal path, because New York's got a very interesting appeal path. The first level of appeal is to the board panel. What is the board panel? Well, you're going to get a panel of 3 workers' comp judges who are going to sit at a panel, and they're going to review the trial judge's decision. After you get that board panel decision, you have a choice. You can go to the full board and ask the entire board to sit down and look at your appeal and reconsider it. Or you can go to the appellate division, which is a law court. It's a civil court. It's part of the New York Supreme Court system. Or you can do both at the same time. So you can go to the full board and at the same time go to the appellate division. If you don't like what the appellate division says, in other words, they rule against you as well, you can then take it to New York's highest court. New York's highest court, their Supreme Court, is called the Court of Appeals. Now, what's interesting about this appeal path is that your first level appeal to the board panel comes with something called an automatic stay. The first level of appeal includes an automatic stay. What does it mean? It means that any thing that you're appealing is stayed. It is not moving forward until the board panel comes back with their decision. That means when you make an appeal of a determination of what is the average weekly wage or the rate of compensation, or you make an appeal as to whether or not the claimant's attached to the labor market or is voluntarily withdrawn, or you're making an appeal as to the degree of disability, yes, strategically you might want to win that appeal, but it also has a tactical impact. And the tactical impact is in the short term, you're not paying those benefits or providing that medical care until the board panel comes back. Now, once I've made an appeal, that doesn't mean I just sit there and wait for the decision. In fact, I think that's a terrible idea. Once you've made an appeal and the appeal is pending and you've got to stay, right? That issue is not moving forward. The claimant's not getting that money. That's an opportunity. You just created an opportunity for your client, and you should be moving very quickly to try to resolve or settle that issue if you can. Now, again, strategically, if the issue that you're appealing is something strategic, like not my employee, I appealed the judge's decision because the judge determined that this was my employee, but I can prove, I've got proofs that say they're not, that's a strategic appeal. If you win the appeal, the case is over, right? You're out, you're done. You did as well as you could do. The case is not continuing on, right? Strategic. But oftentimes the appeal is over, and maybe how much money is moving or if money should be moving at all. Is the claimant a fraud or not a fraud? So those are tactical appeals. There's a tactical impact. Those tactical appeals that you file, you should be immediately following up with your opposing counsel to try to resolve. That's a great opportunity for a Section 32 lump sum dismissal. So be mindful about that. This slide contains sort of a exemplar, a description of how successful we are, what the timelines are, and how much it costs. And I just want to walk through this a little bit because it's very important. You know, this post-trial stuff is really important because it's going to impact exposure in a big way. So the first level of appeal is to the board panel, and yes, you get a stay on any of the issues that you're appealing. How much does it cost? Well, not much. There's no filing fees. It just costs attorney time because we will be drafting a brief in support of the appeal. How long does it typically take for that appeal to be decided? Less than 6 months in general. How often do we get a reversal? That's a win. About 30% of the time. That's a really high percentage. I can tell you statistically about 1 in 4 cases has an appeal, and our history of reversal is about 30%. Now let's say you do not prevail at that level. Your next level or choice is to go up for either a full board review or an appellate division appeal, and you can do both at the same time. So that's where it says concurrent on that chart. The answer is yes to both. Now, this is going to be very costly if you go to the appellate division, because the appellate division has these very particular rules about how you have to print and bind and file things in the appellate division. It's so complicated, and it requires a printing of every record that was reviewed by the Workers' Compensation Court that we use an outside vendor to actually do the printing and binding. And we pass that cost along. And I can tell you, in a very small appeal, with not a lot of issues in dispute, it costs about $5,000 at least just to prepare the record and print it and have it published and then presented to the appellate division. So you have to be really thoughtful, like, are we really going to win this appeal? Is it really worth that appeal? And remember, appeals to the full board and the appellate division, they should be strategic appeals. You should be trying to win the entire case because you're not getting the benefit of that tactical stay. The same thing with the last and highest level of appeal, which is to the Court of Appeals. Again, the Court of Appeals has its own printing and binding requirements, and that alone is going to be very costly and expensive. The time to make a decision can be over a year. In fact, in the decision we just got in April, that had been pending before the Supreme Court, the Court of Appeals for 1 year, so that's a long time. And we do this very rarely, so I don't have a published percentage of the amount of times we get a reversal, but it's just important to understand the entire choices you have after you get a trial level decision or court order. All right, that's a little bit of an overview of discoveries, hearings, trials, and appeals. Let's talk about some takeaways. First, our plan here at LOIS is always to prepare these cases like they're going to trial. Obviously, I only see litigated matters, right? If you're referring a case here to me, it's generally because the case is going to be litigated, and we fully prepare it by going through the full discovery process where we can. Our job is to make the other side live up to its discovery obligations and for us to obtain enough information so that we can get those contradictory medical opinions or develop the record enough so that we can challenge the claimant's version of events. I'll tell you, just as someone who oversees 50 attorneys here in this practice, I know that defense counsel is on their game when they can explain to you in a simple, concrete sentence why they're doing what they're doing. We should have a very clear goal set for every hearing, deposition, trial, and appeal, and you should know it. If the defense counsel can't really explain to you or explain even your likelihood of success in pursuing any of the strategies or tactics that they are deploying for you, I would say that's a real moment to question if defense counsel is actually providing you value or they're just litigating, right? Nobody wants their defense counsel going off on adventures. The next thing I'll say, just my observation, is these cases are like Jenga. It's not chess. These are not math problems to be solved. It's Jenga. You're reacting to what the other side is doing. You're making the best of a moving situation. Our job here is to create opportunity. My job here is to give opportunities to my clients so they can resolve, settle, or dispose of these cases as quickly as possible. If you are appealing cases, just think that most appeals that we're filing are usually tactical. Are going to have a short-term impact on the case rather than strategic. And knowing what type of appeal you're raising is important because it'll help you set that goal and how much money and time and effort and blood and treasure you want to put into that. All right, that's the end of my prepared remarks. Let me come over here to the questions, and hopefully today's subject brought up some great questions. So let me open up the question pane. If you haven't typed your question in yet and you have one, please do it now, because this is my moment to open this up. All right, so far no questions. That's crazy. I mean, we talked about a lot of things today. We talked about what we do on the disclosure side, how we prepare a case, what our mindset is, particularly that one sentence or matchbook mindset of what we're doing here should be simple, concrete, and directed. It should be straightforward, and everybody should understand what our goals are. I talked about the tradesman complaint and the brewing massive fraud decisions that's going to be coming out. And then I talked about appeals. So as I'm looking here, I'm still not seeing any questions pop in. That's strange. We have a lot of attendees. I'm hoping the question box is working. Let me close it and then open it again and see if it populates, because I really thought there'd be more, but all right, I'm not seeing any questions. So let me just talk to you really quickly about some other things. If you like this webinar or you're looking for other ways to learn, check out our newsletter. You can sign up for that on our website. We also publish podcasts. We publish 4 a month. Podcasts, 3 on basic workers' compensation topics, and the 4th one is my partner's podcast called Third Fridays. And this is typically a higher level sort of deep dive into a broad question. He brings in guests to talk about topics in workers' compensation, particularly in New York, and it's really interesting. So I'd recommend it. All right. Still don't see any questions popping up. I guess that means everybody wanted to get back to lunch or do whatever you're doing. Thanks for spending some time with me today, everybody. It was great seeing you. I'll talk to you very soon with our next month's topic. All right. Have a great day, everybody.